I may, for part 2. I'll show you here Monday, April 1st, 2024, 11:32:14 a.m. We go in there, that's 00037, Department of Employment Training Rehabilitation. Filing party is the last column there. And then you can see the dates, 15/15, 15/15. You see there's no other filing party there, and there's no other manner of disposition entered on April 1, 2024. And then I can show you it a little clearer there. You see it again. Still Monday, April 1, 2024. Just a little clearer. I could slow it down if we really need to, and I can present that. But then I take you to this one, where the date, as you see on the bottom, is May 29, 2024. CV 2300037. Pending active is the status. And then I take you to today, April 29, 2025, 2:21 p.m. Now all of a sudden it says case disposed. After I went in and confronted the judicial assistant today, and then she went in and retroactively, ex post facto, Article 1, Section 10, United States Constitution, and Article 1, Section 15, Nevada Constitution. I cannot allow this to be passed. You can't pass a ex post facto law or a law impairing the obligation of a contract. The contract is the trust deposit for the jury trial, and I can't allow it. Then I go in here and I show you this one, which was today, April 29, 2025, 2:10. All of a sudden on 11/15, there's an F-230 event, other manner of disposition, which brought it to this, which was not present on May 29, 2024, which is after the jury trial demand was filed, served, everything. So they went in today after being confronted with a witness against them, myself, and retroactively changed that. Again, trying to criminalize and penalize and punish me. Punish and suppress me. Punish and suppress. Contrary to NRA v. New York, my advocacy and my speech, that it just disfavors. And so, as you can see, that was not there. It's not there. Look, it's not there. So somewhere between May 29, 2024 and April 29, 2025, it had to have been altered. Now, a person who willfully and unlawfully alters a record or other thing filed or deposited in a public office or with any public officer by authority of law is guilty of a Category C felony and shall be punished as provided in NRS 193130. An officer, judicial assistant, is a judicial officer who falsifies any record or paper appertaining to his or her office is guilty of a Category C felony and shall be punished as provided in NRS 193130. And then offering the false instrument for filing a record being that order dismissing the petition for judicial review when there is no such petition in existence. I take you to here, where on the same day, or on the 28th of March 2023, and on the 31st of March 2023, 2 complaints are filed. And neither one of these complaints is requesting judicial review of a administrative decision of Dieter. And then I take you to this docket, which is 7/30 2021, you can see date decision is mailed 7/30/2021. And you can see, I'll go back here. You can see on the bottom, the docket is V21A 02728, and up here, V21A 02728. And that matches this docket here. The appeal determination issued under NRS 612385 is reversed. The claimant is entitled to benefits from August 16, 2020 onward, providing the claimant is otherwise eligible. Now, it's a statement, it's a period. They read it, well, providing that the claimant is otherwise eligible. That gives me room to manipulate and to try and make you not eligible. It's only under NRS. And it's like, no, it's a statement. I'm going to be providing the claimant is otherwise eligible. That's how I read it. Scott Larson, appeals referee. All right. Then the employer appealed that. And so we got it to a board of review. Concurring, Mr. Sweegis, Mr. Billings, the decision of the appeals referee is affirmed in all respects. The claimant is not disqualified under the provisions of Section 612385 of the Nevada Revised Statutes, misconduct, and is entitled to benefits effective August 16, 2020 onward, if otherwise eligible and qualified. Now, I take you to the order here on November 15, 2023. Petitioner requests judicial review of the July 30, 2021 ESD decision denying his claim for unemployment benefits. The petition for judicial review was filed with the court on March 31, 2023. March 31, 2023, with time, everything. Nothing in there is requesting judicial review of that decision. Then I take you to the Nevada Supreme Court, who, if we look down here, that they say they entered it 14th of July 2023, and then subscribed a name and a seal on August 17, 2023, and then didn't file it till August 25th, 2023. Their times don't make sense. But there is no seal of the Nevada Supreme Court affixed. By Elise Hooper, administrative assistant. That's not an admissible signature. That's not even an electronic signature. But yet they keep passing it off like it is, and they keep passing it on to other courts, and other courts keep passing it off as true too, and it's just not. It's just not true. Oh, here is that. No bill of attaining or exposed federal law impairing the obligation of contract shall ever be passed. Okay. Government officials cannot attempt to coerce private parties in order to punish or suppress views that the government disfavors, such as the Sherman Antitrust Act and my right to have a jury trial pursuant to Article 7, Section 2 of the Nevada Constitution for indictment, trial, judgment, and punishment of government officials, so that I can petition trade from another state, bring somebody else in, and not have them have to be under people that are going to commit crimes like this, as I've displayed and showed to you. This one, I show you, they give you 21 days for a docketing statement, 120 for a brief or informal brief. And they say that on this day it was docketed, but then you see they don't put the file stamp up there. But If you go on to the Supreme Court website and you look up 86866, you'll see what day it was docketed, and you'll see that they entered judgment on this 14th day of July 2023, prior to even the first 21 days for the docketing statement to be up. And that was during Chief Justice Stiglitz's term, with 3 other justices. And then Kadish came in 2024, and as I've showed you, is not following the procedure, the internal procedures or the rules either, and is an individual justice or judge acting alone, determining appeals. Same with Herndon now. So that's 3, 4, 5 of the 7 that are doing this. That's disqualifying for 5 of 7 justices in the Nevada Supreme Court. They don't have enough for a panel, so they don't have enough for a quorum, because it has to be 2 of 3 for a quorum, but they don't even have 3 that they could put a panel on that would be qualified and eligible because of all this. And so I'm on my jury trial, and they're restraining that and restraining my trade with another state so that I could petition and say, hey, I've got an open spot here. Let's petition. Can I petition for a special election? Can I petition for something like that? Can I petition to suspend the rules on the 15 years of practice in Nevada and bring someone else in that can be a district court judge, so that way you're not subject to this garbage? Now here's a receipt on the jury trial and everything too. I did narrow facts, everything. And they just are flat out wrong. Here's that executive order that I was talking about with, guess what? A raised seal. That would be the seal that the Supreme Court would have had to affix. That's not there. That's missing. And so, yeah, there it is. I think that goes over all that I needed to go over there. I hope so. Anyway, thanks for the time.